All right. Hi, my name is Camilla Hrdy. I am going to be doing this lecture on definiteness, and we are going to track the progress of the law of definiteness from Merrill to Nautilus. This is going to be a short lecture. It's not required, but you may want to use it in this week's exercise and in general when you're thinking about where the law of definiteness is right now. It's going to be important to know this stuff. So, all right, the reading is quite limited. Just if you want, take a look at the new Nautilus decision that the Supreme Court issued very recently. And all right, let's get started. So we are in week 6. We're talking about claim construction. So let's do a little overview. Claiming, the patent has to conclude with claims that define the legal rights granted by the patent. This we know. Now, we've covered a bit about claiming strategy. What is it that patentees are trying to get when they undertake writing these claims, and usually when their attorney writes these claims? So first, the patentee's incentive is going to be to write claims broadly, right? As broadly as the law allows. But the patentee also has an incentive to write claims somewhat unclearly. Now, there are two ways of looking at this. One is that writing unclear claims is not necessarily a bad thing. It's just a way to deal with uncertainty about the future. You don't really know what's going to happen in the future. You don't know what kind of products others are going to come up with. You don't know what's going to happen in the technology, so you might want to leave a little wiggle room in your claim. The more sort of nefarious interpretation of this unclear claiming practice is that patentees benefit. This is quoting from a brief that was sent in Nautilus by some law professors. Patentees benefit from obfuscating the scope of their rights and keeping others in the dark about their intellectual property. And this is for strategic reasons. They may want to target new ventures and gain an element of surprise when asserting their rights. That's sort of the more nefarious idea. Now, which of these is the one that's usually going on is not always going to be clear. But, so here is our claiming strategy. As a limitation on this, we have the statute. Section 112, as we learned, has two parts. It has 112A, and 112A contains the enablement requirement and the written description requirement. It also concludes with 112B. The specification shall conclude with one or more claims, particularly pointing out and distinctly claiming the subject matter which the inventor or a joint inventor regards as the invention. Now, it's important to understand what these two parts do and the differences between them. So 112A is the enablement and written description. 112B is claim definiteness. Enablement governs the disclosure. What you're looking to do is to make sure that the patent is teaching others in the art, in the how to make and use the invention, and it's sort of a proxy for controlling claim scope. The analysis there is, are the claims sufficiently disclosed to meet 112A? Definiteness has a slightly different focus. It governs claims' linguistic clarity. The goals of definiteness are to clearly distinguish the invention from the prior art, and that's something that the patentee, his or herself, would want to do, would want to clearly say, this is what I am claiming, so it's an efficient way to do that. It's also thought to be a way to give the public notice of what is claimed. So it governs that idea that the patent is sort of a kind of like a real property right that really has to give notice of what is claimed, and that is so that we can avoid uncertainty in the marketplace. And we'll see some of that language quoted in the Supreme Court's Nautilus decision, avoid the zone of uncertainty for enterprise and experimentation. So with definiteness, we're going to be looking at the disclosure a lot. We're definitely going to be looking at it, but we're going to be looking to see whether the claim itself or the language of the claim is definite in light of the disclosure. So it's a slightly different focus. Now, what sorts of claim terms might be challenged as indefinite? So we've got several types here. This is from the PTO's guidelines. We've got words of degree, an oxide that is essentially free of a certain metal. Well, how free does it have to be? Functional language, we're going to see that in one of the cases we're going to look at. That is where language a term is defined functionally. So a chair that is so dimensioned as to be insertable. That just means that it's got to be the right size to be inserted in a car. Now, we also have words depending on subjective judgment. That seems pretty obvious. Something like an aesthetically pleasing screen interface might be subject to a definiteness challenge because it's not quite clear what a person of ordinary skill would think that meant. Open-ended ranges and ambiguous terms. That's where we have two possible meanings, and we're going to see an example of that one. So let's talk about some of the history here. So the first Patent Act did not actually have a definiteness requirement. It did require disclosure. It required that the specification distinguish the invention or discovery from the prior art and enable a workman skilled in the art to make, construct, or use it. But of course, that is the enablement requirement. It doesn't say anything about claims, and it doesn't say anything about a standard for claims. So then after that, only 3 years later, we switch for a while to this registration system. And here, the patents were granted automatically upon registering and paying a fee. So all you had to do was submit an application and it was automatically granted. There was no screening by anyone else for validity pre-grant. Instead, after a patent was challenged or the patentee tried to enforce it, courts would then look at the validity of the patent and decide on their own whether it was valid. So courts ended up doing a lot of the work of developing the law of patents in this period. Now, the registration system, there was some examination. It was just after the grant, but regardless, there were a lot of complaints from inventors themselves even that a lot of worthless and fraudulent patents were issued and the value of the privilege was degraded and a great degree destroyed. So the idea is that because there was very little review of patents before they were granted, patents weren't thought to be particularly valuable, and therefore inventors were less desiring to apply for them. So this seemed to be a problem if we think that one of the goals of patents is to create these incentives. If nobody's applying, nobody thinks they're valuable, they're not creating incentives. So this was actually before we get any kind of statutory change to this, what happens is that the patent bar itself in this situation starts developing formal claiming practice, and the idea is that they were themselves making their patents clearer and better in order to sort of signal their patents as worth paying attention to, as valid, as opposed to these other sort of worthless patents out there. And so Hrdy thinks this is very important. Perhaps the single most important innovation of the patent bar was the patent claim. So this claiming practice is going to be gradually codified. So courts begin to take notice of it, and then the Congress begins to take notice of it. So in the Patent Act of 1836, there is some mention of claiming, and the Patent Act of 1836 does something very important in the history of patent law and in the history of administrative law generally. It creates a patent office, so it gets rid of this. It gets rid of the registration system of automatic registration, and instead now we have a patent office with examiners who are reviewing every single patent before it's granted to see whether it's any good. And here we get the notion that these examiners are not just reviewing for novelty and non-obviousness, they're also, or rather, the non-obviousness law was still developing, but they're not just reviewing for novelty and distinguishment from the prior art. They are looking at the description itself of the invention, the specification, to see whether it meets the requirements. So that's important. We have them reviewing the disclosure as well. Now, what about claims? Are they a part of this? Well, in 1870, we get an amendment of the Patent Act, and here's where the formal claim definiteness requirement is created. Before any inventor or discoverer shall receive a patent for his invention or discovery, he shall particularly point out and distinctly claim the part, improvement, or combination which he claims as his invention or discovery. So what this does is it codifies the practice that was already developing of claiming, and it creates a minimum standard of claim clarity from an external source, from the statute, that patentees have to meet and that their attorneys have to meet in drafting these claims. So claiming is now is now controlled by this new standard in the statute. But of course, the question is, what exactly is this standard? It's definitely a standard. It's not a particularly strict kind of rule. This is particularly point out distinctly claim. What does that mean? So, of course, once again, it's up to courts to decide that. And one of the first cases we have looking at the definiteness requirement is actually a Supreme Court case, Merrill v. Yeomans. And the invention is a new process for treating oils to make a new hydrocarbon oil product. Now the defendants are a dealer in the oil product. They never used the process, but they did deal in the product. So the question in this case is, well, if they never actually used the process that the patentee invented, did they infringe even if they used the product? So of course the patentee is going to argue, well, I claim the whole product and the process, not just the process. So here's the claim. I claim the above described new manufacture of the deodorized heavy hydrocarbon oils, etc., by treating them substantially as is hereinbefore described. So that is the claim. Now, you'll see that word manufacture. Well, this is an example of an ambiguous or potentially ambiguous claim. It has two potential meanings, and the majority of the court knows this and says the word manufacture is one which could be used with equal propriety to express the process of making an article or the article so made. So what does the court do? Well, what the court does is basically perform a sort of a claim construction, what today would be both the process of doing claim construction and the definiteness analysis. It kind of groups them into one, and the court says, well, looking at these claims, it seems clear that the natural meaning of these words is the process only, because otherwise those words at the end of the claim, by treating them substantially as hereinbefore described, that would be useless and it would have no purpose. So the court constructs the claim in a way that limits the claim to only the process. Now, why does the court do this? Why doesn't the court just say, well, the word manufacturer is whatever the patentee says it is? So the reason the court emphasizes that the claim has to be have some level of clarity is that the Patent Act of 1870 has wisely required of the applicant a distinct and specific statement of what he claims to be new and to be his invention. The public should not be deprived of rights supposed to belong to it without being clearly told what it is that limit these rights. So the court says that the 1870 Act creates this external requirement on patentees to be clear, and that one of the major reasons we have that is for the sake of the public. It's this idea that the public also has an interest in claim clarity, and the public here is going to consist of those who might want to use the invention or those who might find themselves infringing. They're going to want to know what the invention covers. So there was actually a dissent in the case. Interestingly, the dissent completely disagreed with the construction of the claim and thought that in fact manufacture clearly referred to the product, the manufacturer, and not the process. But at any rate, this is the holding we have, and it's important. It says there is a claim definiteness requirement. Now, today we have a different procedure for determining claim definiteness. Instead of sort of collapsing claim construction and the definiteness analysis together, we proceed in steps. First, there is claim construction, and that proceeds pursuant to the Markman hearing, and that's going to happen as a matter of law. The court is going to construct the claims, and then sort of during or perhaps after claim construction, the cases we had look at it afterwards. A party, probably the defendant accused of infringement, will bring a definiteness challenge and say this claim does not meet 112B as you've constructed it, court. And then the court will have to decide as a matter of law if, as it's constructed the claim, the patent does meet the 112 requirement that it particularly point out and distinctly claim the invention. So that's the procedure, but what exactly, again, what is the substance of this definiteness requirement? How definite does a claim have to be? So the first thing to know is that when deciding whether a claim is definite, whether the language of a claim is definite enough, we use the basic principles of claim construction, and as you know now, claim definiteness is evaluated from the perspective of a person of ordinary skill in the art, not the judge. It's the person of skill in the art, and that person of skill in the art has access to all relevant art in the field, as well as intrinsic evidence, and that includes the claims themselves, the specification, and also things like prosecution history. So that's a lot of information that this sort of hypothetical person of ordinary skill has access to. So what level of clarity does a claim have to be for the person of ordinary skill? All right, that is sort of the question of the remainder of this lecture. Now, prior to Nautilus, prior to the Supreme Court's recent decision, the Federal Circuit standard was really quite lax. It was only claims not amenable to construction or insolubly ambiguous were indefinite under this standard. And under that standard, indefiniteness motions were rarely granted. In patent cases filed in 2008 to 2009, 176 motions for indefiniteness were filed, which is interesting, but only 17% were granted. So more than any other category of invalidity motion, we get all these indefiniteness motions filed, but very few are granted. So it's kind of a losing claim under this standard. Now let's see how this standard works. How does the Federal Circuit go about determining indefiniteness under the standard? So we're going to look at this case Enzo v. Plager. The invention are several techniques for detecting the presence of a target nucleotide sequence, and the way this is done is by attaching a chemical label to a known nucleic acid. That's called the probe. Now, if the target sequence is present, then the probe will hybridize with it, and this will generate a detectable signal. So it's this process of attaching a label and getting a signal if the target is present. So here is the disputed claim term. One of the claimed probe target signaling combinations contains a, quote, linkage group that is not, its structure is not actually shown. It's only defined functionally. This is an example of functional claiming. It's only defined functionally as not interfering substantially with detection or hybridization. So here is a picture. The B is the nitrogenous base pair, and that is covalently attached to a chemical entity via a linkage group, which is indicated by the dotted line. Now, another way to have done this claim, rather than using this functional language saying that the linkage group has to not interfere substantially, another way to do this would have been to use means plus function claiming, right, which I believe we have done at this point. And so means plus function claiming would have limited the patentee to simply to the means actually disclosed in the specification and equivalence thereof. So this is potentially a way to sort of claim more broadly and more kind of give more flexibility by just using this functional language. So the district court finds that the term not interfering substantially is indefinite, and the reason is the specifications neither set forth how one would gauge substantial interference nor delimit the threshold at which interference with the procedure prevents the claimed method from being implemented. So it basically says there's not enough guidance in the patent that I can see that would give a person of ordinary skill guidance as to what this means. Now, the Federal Circuit reverses and says, no, in fact, the term not interfering substantially is not indefinite. And the Federal Circuit applies its standard, its strict standard of amenable to construction or insolubly ambiguous, and it says it's not indefinite because one of ordinary skill in the art would have known by reading the patents and the intrinsic evidence how much interference would be tolerated. So the Federal Circuit goes through the evidence, and it looks at so it asks what kind of information does the patent give the person of ordinary skill? What kind of information would they have, this hypothetical chemist have? And first, the Federal Circuit points out that the claims as the whole that actually recite, some of the other claims actually recite a linkage group structure that would potentially meet the interference requirement. So there's actually an example given in one of the other claims that might qualify as one of these linkage groups. And then the court looks at the specification and notes that the specification also contains information on the acceptable temperature range for what it would be to not interfere substantially with the hybridization and detection process. And in addition, the specification discloses a few preferred linkage groups. Again, so we have this idea that there's examples given of linkage groups that would meet the requirement. Lastly, and this I think is maybe the strongest evidence, or maybe the weakest, the prosecution history. During prosecution, Enzo overcame an indefiniteness rejection over not interfering substantially by submitting a declaration listing 8 specific linkage groups that did not substantially interfere with hybridization or detection. So the PTO itself was skeptical of this language, thought it was potentially indefinite, and the Enzo overcame it by submitting a bunch of examples of linkage groups that didn't interfere substantially. Now, the patentee didn't go on to claim those specifically. It didn't amend the claims to put those in, but it said, no, these are examples. So the court concludes it's clear enough. And a really important thing to notice here is that the person of ordinary skill is presumed in this opinion to be able to undertake some experimentation in determining the exact level of detection. So the court is saying, look, the claim doesn't have to make it, it doesn't have to do a step-by-step guidance on what exactly this term would mean. We assume that the person of ordinary skill is pretty smart and they can experiment in order to determine exactly what the linkage group should be like. So that is how the court gets around the definiteness challenge. Now, this is not without controversy. Judge Plager, in his statement, says this basically is not a workable standard. The general conclusion of our current law seems to be this: if a person of ordinary skill in the art can come up with a plausible meaning for a disputed claim term in a patent, that term, and therefore the claim, is not indefinite. And Judge Plager goes on to say, now how do we determine the person of ordinary skill? Well, the district court is going to be bombarded with competing expert witnesses who are going to say what the term means, and they're gonna say exactly opposite things. So it ends up with just the court simply picking a side and picking a right interpretation of that for that term. So the Judge Plager's saying, he's complaining that this kind of gives courts too much discretion, and that potentially this could lead to, or I think what's going on here is this concern that because this standard is so discretionary, there is a high chance of reversal. And so you never really know what standard you have to meet with your patent, and you never really know how courts are going to construct claims. Maybe the district court will come out one way, and then, like happened here, the Federal Circuit will reverse. So there's this general complaint that these standards are not clear enough to create a certain area of law that we can rely on. So that leads us to Nautilus v. Biosic, and this is considered to be a needed overhaul of the law of definiteness, but we'll see how much the court has really changed anything. So in this case, the claimed invention is a heart rate monitor for use in exercise machines, and it relies on electrodes in a sequence with a first live electrode and a first common electrode mounted on said first half in spaced relationship with each other, and the claim uses in a spaced relationship several times, and so we don't know exactly where these electrodes have to be, but they're in a spaced relationship. Now, the district court finds that term is indefinite. It's too open-ended. It's too much of a term of degree. It doesn't tell anyone what precisely the space should be, or give any parameters to measure what space. So we don't really know from the public perspective what scope of what length of distance electrodes have to be from one another to be infringing or not. So the district court finds it's indefinite. The Federal Circuit goes and applies its standard and finds that the spaced relationship term was amenable to construction because the claim language, specification, and figures illustrating the spaced relationship between the live and common electrodes provide sufficient clarity to skilled artisans as to the bounds of this disputed term. Now, why did the Federal Circuit think that? Why did the Federal Circuit think that it was going to be obvious to one of ordinary skill what this term meant? Well, the court says user hand placement makes the claim clear. The distance between the live electrode and the common electrode cannot be greater than the width of a user's hands. And that possibly would come from people who have used this exercise equipment and have seen that, well, you've got to have your hands in a certain width, and so we know that the electrodes have to be of a certain space, and it's kind of like, well, this standard is just governed by the market. It's governed by the products that are generally put out there, and they're of course sized for human beings with a certain space of hands, so it really wouldn't have been that hard to know what the spaced relationship should be. So that's not terribly exacting, right? And so the Supreme Court says no, that is not this standard is more amorphous than the statutory definiteness requirement allows. And the court does something very interesting. It basically overturns the Federal Circuit's statutory construction of 112B, and it says that is not the correct construction. In fact, this statute says something else. It says that we read 112, well, now it's 112B, to require that a patent's claims viewed in light of the specification and prosecution history inform those of ordinary skill in the art about the scope of the invention with reasonable certainty. With reasonable certainty. So we have different language, but we're still not entirely clear what that language means, because the Supreme Court did say what it was worried about. It said it was worried about, too much uncertainty again, that there would be this zone of certainty in which enterprise and experimentation wouldn't be able to occur. So we know why the court held this, but still it's not quite clear what the court held, and the court didn't even really decide the case. It remanded, it followed the ordinary practice of remanding to the Federal Circuit in order to then reconsider the space relationship term under this new standard. So it leaves it to the Federal Circuit to decide what this standard means, but we can probably guess that the Supreme Court did not think that the space relationship term at issue did meet that standard. So have there been any post-Nautilus changes? Well, it's not entirely clear. Since Nautilus, courts have still found the vast majority of claim terms to be sufficiently definite. Between June 4th to September 4th, 2014, there were 39 decisions citing Nautilus and considering definiteness challenges, and in 27 of them, the court found every one of the challenge terms to be definite. So it still seems like, it may kind of still be kind of a low bar. But now at a procedural level, there might be a different story, right? Because this new reasonable certainty standard, it asks for more. It asks for more evidence of what a person of ordinary skill would know, because we need to really get at that reasonable certainty between different a person of ordinary skill that might be that might come up at the district level. So we're probably going to see a lot more hearing of experts potentially. And some courts have considered whether that would be the case. They've even considered whether Nautilus actually makes expert testimony and really strong fact-finding a requirement during the definiteness analysis. So that has a lot of relevance for the Supreme Court's next upcoming case, this Teva v. Sandoz case. And there, the court is going to re-examine this question of whether claim definiteness is really a question of law, because as you saw in the sort of procedure of the way this works, claim construction is done, and of course we know that is considered a legal matter. The definiteness determination is also considered a question of law. But that maybe doesn't necessarily square with this idea that when courts are doing the definiteness analysis, they're seeing a ton of evidence, including and evaluating the credibility of witnesses, things like that. So maybe this is more of a fact question. And in that case, right now, the Federal Circuit, gets to review de novo, and that's what happened in the Enzo case, right? Under the old procedure, the Federal Circuit gets to, or the usual procedure, review all these definiteness findings de novo on appeal, and that makes it easier to reverse. But now, if the Supreme Court says, no, actually this is much more of a factual issue, that would mean it would be much harder for appeals courts, the Federal Circuit and the Supreme Court itself, to review these definiteness determinations. So it would give the district courts a lot more say in deciding the outcomes of patent claims. So, quick summary. We looked at how the first Patent Act didn't have an actual claiming requirement, but gradually the patent bar developed this claiming practice, and then in 1870 Congress creates this statutory definiteness requirement, which is then sort of fleshed out by the courts as to what it means. Under the Federal Circuit's old standard, only claims not amenable to construction or insolubly ambiguous are indefinite. Under Nautilus, the Supreme Court's new standard, claims must inform those of ordinary skill in the art about the scope of the invention with reasonable certainty. And that's a slightly higher standard. Now in TIVA, the next question, is definiteness really a question of law? How easy is it for appeals courts to overturn trial courts' definiteness decisions? So that is the lecture, and I look forward to discussing this and claim construction generally with you guys this week, and enjoy doing the exercise.